Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Friday, February 27th, 2026 at 2:35 in the afternoon. Back from a short break now. It's time for some committee discussion on the avenues that we want to go in. Maria, if you'd like to join us. Hi, Maria.
Hello. It's to be back.
So how do you, welcome to the chair of honor.
So I think, yeah, one question about there was a lot of discussion on third-party debt collecting. How do we regulate debt collectors in the state, and is there anything we could add to the bill that I think we want to make sure that they're following this law if it becomes law, and then who would oversee that?
So at the risk of sounding like I know more than I actually do know, because I've only been researching this like a couple of days. But so the state, the Attorney General has adopted rules on debt collection practices pursuant to their Consumer Protection Authority, which has some overlap with the federal law on debt collection practices. A few things just quickly. I think what you heard first from Andrea is correct, that original creditors generally do not have to comply with the federal law. It applies to third-party collectors generally. However, under the state rules, debt collector includes a creditor, the original creditor, trying to collect on their own claim. In terms of anything that you passed in state law that conflicts with in any way the rules would have to be amended to comply with state law. They're subject to state law, basically. So, and I think you even, Chris Campbell, I think, spoke about this earlier. I think you talked about I think you asked them, should they be amending the rules to conform with this? And they said no, because we will do that anyway. So that's like almost the extent of my knowledge on debt collection practices. So if you want to hear from the AG's office or Rick later, just to confirm.
I think maybe we will maybe review what they have in their wheelhouse and make sure that people are complying. But if it's under consumer protection, I think it's pretty broad authority to regulate. But we want to make sure because then we can, in this bill, add some punch to it if we need to.
I don't know if it was right. I read the rules some more. Did the Attorney General have the authority to do an examination of compliance with the law, absent, some allegation?
I don't know specifically.
That's fine.
Yeah.
But I think you're talking about an examination would be like on a credit union or any of the financial institutions that are subject to state to DFR. And I don't know, but then I don't know what the Fed does, but.
Actually, I was thinking just generically, in terms of whoever is obligated under this bill,
Yeah.
whether someone has the authority to examine whether they're compliant with the law.
Yeah, I know. I wonder, yeah, but
I don't know.
I mean,
I think with the state regulator, you licensed lenders, state chartered, that's cool.
yeah,
And then that's why I was asking the debt collection agencies too. But then
but if they're under,
Yeah,
the debt collect, if they're under the Attorney General's purview under the Consumer Protection Act.
but they don't have, I don't think the AG has the authority to.
No, you actually just reminded me, because the Attorney General has broad investigative authority under any of the consumer protections in chapter 63, including the rules. So presumably, if they felt,
Maybe
they
that's
just, yeah,
a question for
I
them,
would confirm with.
whether they need, say, some sort of reason to believe that a violation has occurred before they conduct an investigation, or whether they have the ability to just sort of periodically, find it look.
They've got a few complaints that,
Yeah.
This third party debt collector, we've told them it's course debt, and it's still pushing,
Yeah,
they could.
investigate.
So we will ask the Attorney General to come in on Tuesday
That would be great.
and have that discussion. So I think what's before us now is the two instances of, do we remove the phrase that talks about evidence and just leave it at determination? And the other is, we have three options there.
Where's the section on the evidence?
Page 8, starts at line 11.
11 and 15.
Yes, D, subsection D. Remove the phrase including identification of the evidence relied upon.
What about if we have description of the evidence relied upon?
Basically,
kind of
we
the
gotta be
same.
careful that
Yeah.
if they're relying on some evidence that they found that this is that it's fraudulent.
Yeah.
We really don't want them giving the evidence out.
Right.
Are we just having a discussion about that? Okay, so the point about whether the regulator has the authority to proactively go out, I mean, that makes a difference to me in terms of whether that phrase is in there. Including identification of the evidence. If I was confident that, somebody had the ability to go out and say, wait, did you really have, let's pull some random files here and see if you had a good faith basis. I'd be more comfortable, deleting that phrase, but that would make me uncomfortable if people didn't have that.
I think it sounds like, at least on the state side, the DFR would have that authority.
Yes and no.
Examination.
It would depend on whether it was whether the lender was a state chartered
Right,
institution or not. There'd be
But then-
negative, not.
Yeah, but then you also,
For the record, Joe Valenti, Director of Policy at the Environment.
but you also work with the FDIC and NCUA when they come in for examinations as well.
If it is a federally chartered institution, our authorities are limited.
Right, but there is cooperation between DFR and FDIC and NCUA.
There is, but there's limits to what we can do from
Sure.
one that's not.
Yeah. But there could be that discussion with the federal regulators that we have this law, take a look and make sure that they're doing their due diligence when it comes to course debt.
Yes, and that you might also run into an issue for sort of non-depository lenders, online lenders and the like, who we may or may not be able to examine.
Yeah, and who regulates that? If outside of our purview. Is the Fed?
Well, they should, most of them should be registered and licensed with us. I'm just thinking about edge cases here where we may not cover the entirety of the market.
But wouldn't they be a licensed lender? Wouldn't they have to be a licensed lender in order to perform that function? And would you have the examination authority over licensed lenders in that sense?
If it's a licensed lender, then yes, that would make sense.
And then I think based on the AG's broad authority for third party debt collectors, I think I'm comfortable with removing it.
Yeah. Me too.
Michael,
Can you repeat what you just said?
I said, based on, I mean, just this conversation with state regulators, and they do work with the federal regulators where they don't do they can talk to the federal regulators and say, look at this. Also with the Attorney General's broad authority under the Consumer Protection Act, and I feel comfortable that they can actually take a look to see if there's things that are going on with a third-party debt collector.
While we're on this phrase, this clause here. I'm not sure if this is this difference by distinction, but when I look at good faith and that sort of concept, it's from the perspective of the actor. Not necessarily, and it might be entirely in good faith, but maybe it's not reasonable kind of thing. And so I'm wondering whether some notion of it being a reasonable determination might be.
Provide a reasonable good faith basis.
Yeah.
I did a little bit of just sleuthing around on some of this. Good faith basis is defined, one of the definitions is an honest, reasonable belief supported by some facts or law that your position, action, or statement is legitimate, even if it later turns out to be wrong.
So reasonable is in the definition.
Yeah, that's the point of making sure that reasonableness it's somehow incorporated.
Else and suspenders.
Oh.
Yeah, so I guess I just had a question. If we have a good faith basis, can it be a simple decline? Your application has been declined. Does that constitute a good faith basis? And if it doesn't, and we just clarify, does not mean a sentence of a single sentence that declines the application or something like that, right? Like I'm just trying to put a little bit more meat on it if it's possible, but if it's unnecessary, I will.
The other thing that I found about this was in civil litigation, you can state the way it's described here, state sufficient facts in the complaint to make the claim plausible. Can we do something like that where he's not required to reveal some of that information? But, the word I use is vaguely specific.
Sure how that works legally, but.
Right.
That topic can I ask, Maria, I know you're busy looking for some things, but good faith shows up a lot in VSA. It's a really common phrase, which either is helpful to us or can be unhelpful to us. And I'm just curious in talking to legislative counsel, is that broadly understood? Or is it the kind of thing where over the years, legislation has been tweaked, to make explicit what was baked into what, Representative Nicholas read to us, for example?
So I don't know generally. I think it's probably one of those standards that depends on the context. Right. So, and ultimately, if there's a dispute, it will be up to the courts to determine was there a good, it's like almost like a reasonableness standard, right? It might.
It's interesting. It's interesting to me that phrase would come up so frequently, including in data broker security breach, that does not include good faith, but in office languages that if it's a sticky wicket, then we have made a mistake of having it show up 401 times in a statute search.
I understand. Yeah.
But perhaps it's not that sticky of a wicket then.
I think it would be enough to prevent just an arbitrary denial. Like, I can't imagine, there's no good faith investigation. You have to do an investigation. So if you haven't done any investigation, you just deny it, then I think you violated. If there are any concerns and, you want to be more specific and include reasonable, good faith, you know? There's no harm in doing that.
Can you, over the break, touch base with Judge Zonate and ask how the judiciary treats good faith basis?
I can ask Michelle.
Jonathan has said it's throughout the statutes. So there must be case law on how judges determine that.
But one of, if we go in the direction of not including a requirement to include the identification of the evidence relied on, I think it might be, and so we're kind of relying on the AG or somebody else to follow up on occasion to make sure that it is good faith. I think it would be important to have the creditor make a record somewhere so that when the regulator is going back and taking a look at it, they have the information necessary to decide did they do a good job or didn't they do a good job?
Chris can
Your Bankers Association, that's a given. I mean, of course, we're gonna have a record of it. We've got to have something in the files that we base the decision on. We've got to keep that in the files, and then we've got to adhere to record retention statutes. I don't see how that would ever get around not having it.
I hear you, but I'm just thinking about a licensed lender, that might be doing business from out of state.
If they're registered with, if they're not registered with DFR and they're a licensed lender in Vermont, I think they're in violation. But if they're registered with DFR, they've got record retention statutes that they have to follow DFR. It's not just federal record retention statute.
So the including identification of evidence relied upon, I'm not thrilled with just completely removing it. I think that there's some good to having more than just a you're denied letter. But I can also understand that there might be information that we shouldn't be providing. And we've dropped reasonable multiple times in this conversation. Would it be something that we could do where the notice shall include reasonable, including reasonable identification of evidence relied upon. This way it says, hey, you really should provide as much as you can, but if you can't provide it because it's not good to provide it, it allows you the out, but it sets an expectation that you should provide some sort of information. It's better than removing it, but it's also better than keeping it in as it is, because I can understand the reasoning for it. Reason.
The other thing that I was thinking, this may or may not solve your problem, is including identification of the evidence relied upon when fraud is not determined, or when there is no reasonable something of fraud, right? Reasonable possibility of fraud, something like that, right? Like, is there a way to, because there are cases, or when it won't reasonably put the bank or put the lender in a compromised position, right? Like, there's something along those lines. But again, this is, I don't know legally what we need, if it even makes sense.
Would a way to back that down a little bit would be to provide a rational justification, right? At least make your argument without necessarily giving all of the details. I don't know if that's even a construct that could be legalized, but something, you made a rational justification, say, this is why we came to this conclusion.
I just wanna remind, by the definition I've looked up here for good faith, honest, reasonable belief supported by some facts or law that your position, action, or statement is legitimate. So in a sense, the word good faith reasonable is already built in there.
Why don't we hear what Maria comes up with from Judge Zonay?
Sure.
I think we need to understand how the judiciary in case law determines what good faith is. And I don't, we can sit here for the next 2 or 3 hours and keep going round and round.
That would be a good faith effort.
Still wind up in the same place.
I'll just mention this. So under the UCC in Vermont, there is a definition of good faith, and it means honesty in fact and the observance of reasonable commercial standards of fair dealing.
It's a reasonable word.
Anyways, I'll just leave you with that.
And then give a list of things I'd like to see.
A list of things.
List of things. I know.
Email.
It's tough. It's only like 2 or 3. So number 2 is my preference for, because we're doing rounds.
That's the type of thing that we're gonna.
Yeah. So I definitely would prefer you can continue debt collecting, but you can't transfer and you can't sell. I think that,
Well, let's take one thing at a time.
Okay.
So where is everybody at? 3 options we have.
So we're switching gears.
Yes, because I think we'll
Okay.
get more information about,
Okay.
that was, I think what we.
Yeah.
Maria just read us out from the UCC is, but let's hear what judiciary is.
I just need to confirm that.
So the next, the second piece on the table is the which option?
I mean, I'm comfortable with option 2. I would agree. It's kind of that middle ground.
As somebody who had a mortgage sold 3 times in 5 years, I like option 2 and the stability it would afford as well.
I think option 2.
I don't have a clear decision at this point. I can't. All 3 of them, like I don't, I mean, I do think that I do think it's important to prohibit transferability just because this does seem to be some sort of like disputed type of debt. And it seems like there's gonna need work on more categories, so I don't think it should be able to be transferred.
I would caveat that I want to make sure with the DEG really does have the authority to deal with that issue of whether those determinations are made properly, good faith, whatever. That would be, number 2 would be okay with me. But I need a little more information, I think, about how that other section that we've just been talking about is constructed, plus some real good assurances from the Attorney General's office that they can proactively, maybe on a regular basis, try to figure out whether it's being complied.
I feel like I'm on mute with Emily and Herb.
I think I could be okay with number 2. Yeah, I mean, I have mixed feelings just because I do hear that the debtor is gonna be, so now they're back in being collected. And really at that point, their only possible thing is to go to court, right? To rectify that, and recognizing that folks in that situation don't have much for opportunity assets or necessarily skill set to do so. So I do worry that they're gonna get left behind. I could live with.
Yeah, understanding that, we'd be the eighth state to put this in place. There's not a lot of information nationwide. There's some, but not a lot on how this impacts lending institutions and people who are victims. I could live with starting with two and watching what happens in the state, and hopefully down the road, making it much easier for victims in these situations, and even better, supporting victims in many more ways than this. That's really fine. This I see as a small first step, but it's a first step, and that's a good thing.
So for now, it's option 2. So remember, we have a report that we'll get from DFR. And, it talks about other relevant parties to consult with besides bankers and the credit unions. But maybe we ask the DFR to also consult with legal aid so that we're in the Vermont domestic, domestic finance network. So we add those two to the report that DFR consults with them as well, which will give us a better idea, not just what the banks and credit unions and financial institutions are doing, but also what legal aid is seeing and what the problem that they're seeing too.
I think the report right now only is on transaction hold, so we might need to modify that a little bit to get more.
So that's right, that's the transaction.
And use
So
maybe
maybe we
the,
ask DFR to do the same thing with this.
Yeah.
With, the banks can, and the credit unions provide that information, you can collect that. But utilize the other mechanisms. Yeah,
yeah, like 3 years after it goes into effect seems like a reasonable amount of time to get good data back.
I wouldn't mind seeing in that.
but maybe we can get some preliminary information every year,
Yeah.
like, a year, 6 months, so we probably. We start the preliminary report side. Get some 27.
But isn't this effective 2028?
It's not going into, okay, so then. Push it out for,
We can make it effective sooner, so we get reports.
I mean, can we do like the reporting?
I'm joking.
maybe.
Too soon?
So it's supposed to affect July. So in December of 29, that makes sense, or is that too soon? Just for a preliminary. Michael.
All right, so I do want to make sure that the Fair Debt Collection Practice Act or whatever Vermont has is set up so that if you send a letter of cease and desist, no more letters, no more phone calls, no more communications. Because that puts it into this nebulous area where if the debtor wants to get rid of it off their credit, they have to take it to court. If the banker wants to collect the money, they have to take it to court. And because I was under the impression that if you send that letter, cease and desist, they don't contact you anymore.
I think what we'll do as well, we've already talked about it, bringing the Attorney General, but also having Rick come in and talk to us about the Vermont version of that. So that we have a good understanding of, and Rick needs to, while we're way blown up on that, because he's not very familiar with it, on the Vermont version of it. So when we come back, he'll give us that information of what is in current statute now.
For me, I would like to see that. If it's not, I would like to see that in the bill.
We can certainly talk about it.
yeah,
We have to see what's in there first. before we can-
no, and I get that. I just wanna, I'm just concerned that it's not, and if it isn't, I certainly think that putting that in there is,
Did work on that. 22 years. I remember it. Okay. So I think we determined the path forward. We'll have a few more questions answered when we come back. So we'll take it up that Tuesday when we come back. And we're waiting for judiciary is also going to work on there. We could bring that to a put it in bill. I think we're pretty close completed on this, so we'll finish it. I don't think anything else?
Anybody would like to sign on to the resolution pertaining to the 15th anniversary of the Fukushima disaster? I'll need to know by 5 o'clock. I sent you all a draft of the language we worked up with Michael Chernick. So just take a peek and let me know.
All right. Well, it's a wrap. Everybody have a good week off, get recharged. Things are gonna get hectic the first 2 or 3 weeks that we're back. We have a lot of work to do still. Exciting. So with that, I think we can